places of worship under Martyn's law, and they have a buy from the legislation in so much as if they have or can reasonably expect 800 people or more, they are not in the enhanced tier, they're still in a standard tier. So they have to put in place public protection procedures so far as is reasonably practicable. What good looks like for those organisations is they need to have shown a methodology for assessing what is reasonably practicable, given their budget and amount of staff and volunteers they have on site. And this can be hugely difficult for some of these organisations because you have some very big places of worship that can get many thousands of people through the doors all the time. They hold concerts, they hold events, there's all sorts of activity that goes on, and they will have a sizable budget, as opposed to a community church that only at Christmas does it get 200 people on site, but it's still in scope and has a much more limited budget compared to some of those bigger ones. And the regulator is going to want to see very different amounts of implementation of your public protection procedures because one site clearly has a lot more budget than the other. So there needs to be a methodology to show this is what we've deemed as reasonably practicable, this is why we've deemed it, and then the actual public protection procedures themselves in great detail, and then the evidence that you've trained all your staff and volunteers, remember there's a lot of volunteers that work on places of worship, so that they can all act correctly in the event of a terrorism incident.